It finally happened. Judge Caldwell lost all patience and the Marshals did not hesitate. What you're about to see is unprecedented. A federal judge pushed beyond his limit, ordering immediate removal of a defendant from his courtroom. No warnings, no second chances. Marshals moving in before the words finished leaving his mouth. And then the bombshell no one expected. Bail denied on the spot. This wasn't theater. This wasn't grandstanding. This was a federal judge declaring in front of cameras and a packed courtroom that enough is enough. When a sitting judge looks at armed federal officers and says, "Remove him now," you know something catastrophic just unfolded. Here's exactly what happened and why everyone is talking about it. So, what triggered this extraordinary moment? In his courtroom, on what was supposed to be a routine pre-trial hearing, Judge Caldwell witnessed something that shattered his legendary patience, a patience that has lasted through decades on the federal bench. This isn't just another courtroom outburst caught on camera. This is a federal judge making a calculated decision to invoke his full authority in real time, with the entire legal world watching. The defendant, who had already pushed boundaries in previous appearances, crossed a line that Judge Caldwell made clear would never be crossed again. What happened in those explosive 90 seconds is now being studied by legal experts across the country. Former prosecutors are calling it a masterclass in judicial authority. Defense attorneys are calling it terrifying. And I have the courtroom accounts, the legal filings, and expert analysis right here. But here's the thing. What triggered the removal is only part of the story. The bail denial that followed, that's where this gets truly unprecedented. Because when a federal judge revokes your freedom mid-hearing with marshals already flanking you, your entire legal strategy just collapsed. Let me show you exactly what they're trying to spin. Here's what actually happened inside that courtroom the moment everyone clicked to see. The hearing began at 10:17 a.m. According to courtroom observers, the defendant entered with what witnesses described as visible contempt, refusing to acknowledge the judge, whispering loudly to his legal team, and at one point appearing to laugh during procedural statements. This is it. This is the moment that changed everything. Judge Caldwell, after addressing preliminary matters, turned to the issue of the defendant's compliance with pretrial conditions. That's when the defendant interrupted, directly cutting off the judge mid-sentence. According to reporters present, the defendant stated, "This court has no authority over me. I don't recognize this proceeding." Judge Caldwell paused. The courtroom went silent. He gave the defendant one opportunity. Just one, he said calmly. "You will conduct yourself with respect for this court, or there will be immediate consequences." The defendant's response? He reportedly turned to the gallery and made a dismissive gesture toward the bench. That was the trigger. Judge Caldwell's voice, according to multiple witnesses, shifted instantly. Not louder, but colder. He stated, "Marshals, remove this individual from my courtroom immediately. We are done." Two U.S. Marshals positioned near the side entrance moved without hesitation. The defendant barely had time to react before he was physically escorted toward the holding area. But here's the kicker. Judge Caldwell wasn't finished. As the Marshals moved in, the judge continued, "Let the record reflect that the defendant has demonstrated willful contempt for this court's authority. Based on this conduct, combined with documented violations of pretrial release conditions, the court is revoking bail effective immediately." Revoking bail in real time with the defendant being physically removed. Legal analysts who reviewed the transcript emphasized that this wasn't impulsive, it was calculated. Judge Caldwell cited specific violations, missed check-ins with pretrial services, alleged contact with witnesses despite a no-contact order, and social media posts that appeared to threaten court officers. The defendant had reportedly missed 3 scheduled check-ins over the previous month. Court documents show that pretrial services had filed 2 formal notices of non-compliance, both of which had been addressed in earlier hearings, with warnings. Those warnings expired the moment the defendant interrupted the judge. The bail revocation order filed within the hour contained language rarely seen in federal proceedings. Judge Caldwell wrote, "The defendant has demonstrated a fundamental unwillingness to comply with the conditions of release and has shown contempt for the judicial process itself. Continued liberty poses an unacceptable risk to the integrity of these proceedings." and it gets worse. According to sources familiar with the case, investigators had been building a case for bail revocation for weeks. The defendant's social media activity, despite being ordered to limit public statements about the case, included posts that prosecutors argued constituted witness intimidation. One post, according to court filings, referenced individuals believed to be cooperating witnesses by their initials, with language the government characterized as thinly veiled threats. Judge Caldwell, in his written order, addressed this directly. The defendant's public communications demonstrate not merely poor judgment, but a calculated effort to undermine the administration of justice. Former federal prosecutor Marcus Webb told legal observers that this level of documentation suggests the judge had been waiting for an opportunity. This wasn't reactive. The revocation order was ready. The defendant's courtroom behavior simply provided the final justification. The defendant is now being held without bail pending trial, a status that in federal court is extraordinarily difficult to reverse. His legal team has 24 hours to file an emergency appeal. Hit that subscribe button right now, because what happens next in this case could reshape how federal judges handle defiant defendants nationwide. I'm covering every development as it unfolds, and you'll want to be here for all of it. Now, you've seen what happened, but here's how we got here, and it makes Judge Caldwell's decision even more justified. This confrontation didn't emerge from nothing. Tensions had been escalating for months, fueled by the defendant's pattern of pushing boundaries, testing judicial patience, and treating court proceedings as a platform rather than a legal forum. Everything changed during a hearing 3 months ago when the defendant first challenged Judge Caldwell's authority publicly. According to court transcripts from that earlier hearing, the defendant questioned whether the judge had jurisdiction to impose any pretrial conditions at all. A legally baseless claim that the judge dismissed but noted for the record. At that time, Judge Caldwell stated, "This court's patience should not be mistaken for weakness. I am providing latitude. That latitude can be withdrawn." The defendant apparently interpreted that warning as an empty threat. Over the following weeks, pretrial services documented a pattern of technical non-compliance. The defendant would check in late, sometimes by hours, sometimes by days. He would provide incomplete information about his whereabouts. He would submit forms with missing signatures. Each violation individually might seem minor, but federal judges recognize patterns. On a hearing 6 weeks before the explosive removal, Judge Caldwell addressed these violations directly. He stated, according to the transcript, "I am putting you on formal notice. One more documented violation, and I will entertain a motion for revocation." The defendant's attorney assured the court that compliance would improve. It didn't. 2 weeks later, pretrial services flagged the social media posts. The posts, while not explicitly threatening, referenced the case in ways that skirted and arguably crossed the protective order. When prosecutors filed a formal motion for bail revocation, they included screenshots, timestamps, and expert analysis arguing that the posts were designed to intimidate witnesses. The hearing where the Marshals moved in was scheduled specifically to address that motion. Judge Caldwell had already reviewed the evidence. He had already consulted with court security. The Marshals were positioned specifically because the judge anticipated the possibility of a confrontation. What the defendant didn't realize, what his legal team apparently failed to convey, is that he was walking into a courtroom where every contingency had been prepared. When he interrupted the judge, he wasn't testing an unprepared jurist. He was triggering a response that had been planned for exactly this scenario. Smash that like button if you're following this, because understanding how we got here is crucial for understanding what happens next. Drop a like so more people see this breakdown. I read every single comment, and I want to hear your take. The bombshell moment came when the Marshals physically positioned themselves on either side of the defendant, and he still didn't stop. According to witnesses, even as federal officers closed in, the defendant continued speaking. He reportedly said something to the effect of, "You can't silence me. Everyone watching knows what this is." Judge Caldwell's response was immediate and devastating. He stated for the record, "Let the transcript reflect that the defendant is continuing to disrupt these proceedings even as he is being lawfully removed. This conduct will be incorporated into sentencing considerations should there be a conviction. The courtroom felt absolutely silent. Reporters present described the atmosphere as electric, a mixture of shock and, among some observers, visible relief. One court sketch artist who has covered federal proceedings for 23 years told media afterward, "I've never seen anything like it." The judge's voice never rose, but the authority was absolute. As the defendant was escorted through the side door, he reportedly attempted to turn back toward the gallery. Marshals physically redirected him. The door closed. Judge Caldwell, without pausing, addressed the remaining attorneys. "We will take a 15-minute recess. When we resume, we will proceed with the government's other pending motions." And just like that, it was over. Except it wasn't, because what happened in those 90 seconds is now reverberating through every federal courthouse in America. This was a message, and every defendant watching got it loud and clear. Stay with me, because the implications of this are massive. But first, drop a comment right now. Did you see this coming? Do you think Judge Caldwell was right to act this decisively? I read every single comment, and I want your take. This isn't the first time a federal judge has ordered marshals to remove a defiant defendant, but the circumstances make this unprecedented. Think back to the Chicago 7 trial in 1969. Judge Julius Hoffman, facing relentless disruption from defendant Bobby Seale, ordered him bound and gagged in the courtroom. That decision was later criticized as excessive, and Seale's conviction was eventually overturned. The key difference now, Judge Caldwell didn't try to continue with a disruptive defendant present. He removed him immediately and revoked bail, eliminating the possibility of further courtroom confrontations entirely. Then there was the 1988 case of tax protester Irwin Schiff, who repeatedly interrupted federal judges with claims that income tax was unconstitutional. He was removed from multiple courtrooms and eventually barred from filing pro se legal documents. But even Schiff wasn't held without bail for courtroom conduct alone. What makes Judge Caldwell's decision different? What legal scholars are now analyzing intensely is the combination of immediate removal and bail revocation in a single moment. Professor Sarah Chen, who teaches criminal procedure at Georgetown Law, explained, "Typically, these are separate proceedings. You remove someone for contempt, then schedule a later hearing on bail." Judge Caldwell collapsed both into one ruling, and he had the documentation to support it. That documentation is crucial, because Judge Caldwell's order didn't rely solely on the courtroom outburst. It cited weeks of accumulated violations, building a record that justified immediate detention. This is what experienced federal judges do. They don't react impulsively. They build cases, even against defendants in their own courtrooms. The pattern is clear. When defendants test judicial authority repeatedly, the consequences compound. Now, however, those consequences arrived all at once, in front of cameras, in front of the legal world, in a moment that will be studied for decades. Judge Caldwell didn't just remove a disruptive defendant, he established a template for judicial response that courts nationwide are already discussing. Legal experts are calling this a watershed moment for judicial authority in federal proceedings. Marcus Webb, a former federal prosecutor with 18 years of experience in high-profile cases, told legal media that Judge Caldwell's actions were textbook but elevated. He explained, "Every first-air prosecutor learns that you build a record before you make a major move." Judge Caldwell clearly had weeks of documentation ready. The courtroom confrontation was just the final piece, but executing both the removal and the bail revocation in real time, that takes supreme confidence in your legal position. Webb added that the defendant's legal team now faces an almost impossible appellate challenge. You'd have to argue that the judge acted without sufficient cause, but the record shows repeated warnings, documented violations, and conduct that any reasonable jurist would find intolerable. Meanwhile, constitutional law professor David Armitage from Harvard Law School emphasized the broader implications. This sends a message that federal courts are not platforms for political theater. Armitage stated, "Judge Caldwell made clear that the courtroom is his domain, and defendants who forget that do so at their peril." The constitutional issues are minimal. Defendants have no right to disrupt proceedings. A criminal defense attorney speaking on background offered a more cautionary perspective. Defense lawyers are watching this closely. The concern is that judges might feel emboldened to act more aggressively on thinner evidence. Judge Caldwell had a strong record. Not every judge will. But even defense-oriented analysts acknowledged that the defendant's conduct was extreme. Former public defender Natalie Reyes, now a legal commentator, admitted, "Look, there's zealous advocacy and there's self-destruction. This defendant chose self-destruction. No lawyer could have saved him from himself in that moment." Reyes noted that the defendant's attorney appeared visibly distressed during the removal. You could see it in real time. The lawyer knew exactly what was happening and couldn't stop it. This is a nightmare scenario for any defense counsel. What makes this case particularly significant, according to multiple analysts, is the clarity of the record. Judge Caldwell's written order, filed within an hour of the courtroom confrontation, runs 11 pages. It documents every missed check-in, every borderline social media post, every warning issued in prior hearings. Former appellate judge Patricia Hammond, now retired, explained that order wasn't written in an hour. It was ready. He was waiting for this moment, not hoping for it, but prepared for it. That's the difference between a reactive judge and a strategic one. If this analysis is valuable to you, smash that like button right now. It genuinely helps more people see this coverage. The algorithm rewards engagement, and your like helps this reach people who deserve to know what happened. So what does this actually mean going forward? First, the defendant faces immediate detention until trial, which could be months away. Federal detention pending trial is notoriously difficult to reverse. The defendant's attorneys would need to demonstrate either that Judge Caldwell abused his discretion, unlikely given the documented record, or that changed circumstances warrant reconsideration. But here's the problem. The defendant's conduct in the courtroom is now part of the permanent record. Any appeals court reviewing the bail revocation will see exactly what happened. They'll read the transcript. They'll see the documentation of prior violations. On one side, the defense will argue that bail revocation for courtroom conduct is disproportionate. On the other, prosecutors will point to a pattern of behavior, demonstrating that the defendant cannot be trusted to comply with court orders. The second implication, this affects how every federal defendant conducts themselves going forward. Defense attorneys nationwide are already sending updated guidance to clients. The message is clear. Federal judges have authority. They will use it, and courtroom defiance will not be tolerated. Sources familiar with federal public defender offices indicated that training materials are being updated specifically to address Caldwell-type scenarios. Attorneys are being instructed to have explicit conversations with clients about courtroom department conversations that document the client was warned. Because if a client acts out after being specifically warned, the attorney has protection. The documentation shifts blame to the client's own choices. Third, this establishes precedent for combined removal and revocation orders. Prior to this case, most legal practitioners assumed these would be separate proceedings. Now, Judge Caldwell has demonstrated that when the record supports it, both can occur simultaneously. Legal scholars are already debating whether this expands judicial power or simply clarifies existing authority. Professor Chen from Georgetown suggested the authority was always there. Judge Caldwell just showed everyone what it looks like when used decisively. The implications for defendants with pre-trial release conditions are significant. Any violation, even minor ones, now builds a record that could be deployed instantly if courtroom conduct deteriorates. Fourth, this changes the calculus for defendants considering disruptive strategies. Some defendants, particularly those with political motivations, have historically used courtroom appearances as opportunities to make statements, challenge legitimacy, or generate media attention. Judge Caldwell's response demonstrates the risk. You might get your moment of defiance, but you might also spend the next several months in federal detention, while your lawyers scramble to undo the damage. The message to future defendants is unmistakable. The courtroom is not your platform. The judge controls that space. Absolutely. And if you forget that, you will be reminded in the most consequential way possible. Every defendant currently awaiting trial in federal court just witnessed what happens when you push too far. Many of them are reconsidering their strategies right now. And then the defendant's team made it even worse. Within hours of the courtroom removal, statements began emerging from the defendant's supporters that can only be described as incendiary. Instead of acknowledging the documented violations, the defendant's allies attacked Judge Caldwell personally. Social media accounts associated with the defendant's circle called the judge a tyrant in robes and accused him of political persecution. One post, which has since been screenshot and preserved for potential court review, stated, "This so-called judge just showed America what real fascism looks like." That post has already been flagged to prosecutors. The defendant's formal legal team took a more measured approach, but barely. Their statement acknowledged disappointment with the ruling, but promised an immediate appeal. What the statement notably did not do, take any responsibility for the defendant's documented violations. Here's the problem with that response. It's likely to backfire spectacularly. When your client has missed multiple check-ins, allegedly violated a no-contact order, posted borderline threatening content on social media, and then interrupted a federal judge mid-sentence, attacking the judge's legitimacy is not a winning strategy. Legal analyst Rachel Torres pointed out that the defendant's response actually strengthens the government's position. They're essentially proving Judge Caldwell's point. The defendant and his circle don't respect judicial authority. Every attack on the judge reinforces why he shouldn't be trusted with pretrial liberty. Torres added that prosecutors are almost certainly monitoring the post-removal statements. If anything crosses the line into threats or witness intimidation, those become additional charges. The defendant is in federal custody right now, but his supporters are still creating legal exposure for him. When your defense is attacking the judge rather than addressing the evidence of violations, you've already lost the legal argument. The 11-page order documenting the bail revocation speaks for itself. It contains dates, times, screenshots, and direct quotes. It references prior warnings on the record. Against that documentation, calling the judge names on social media accomplishes nothing, except potentially adding contempt charges. The defendant's team has 48 hours to file a formal appeal of the bail revocation. Legal experts give that appeal very little chance of success. But beyond the immediate legal fallout, this is really about something much bigger. This is about the rule of law. It's about whether courts can function when defendants treat them as theaters for performance, rather than institutions demanding respect. Every day, federal judges preside over cases involving people who believe the law doesn't apply to them. They face defendants who think loudness substitutes for legal argument, who believe that defiance will somehow overwhelm judicial authority. Judge Caldwell's response demonstrated otherwise, when he said, "Marshals remove him immediately." And when those marshals moved without hesitation, he showed every defendant in America that courtrooms have rules, that judges have power, that the system, when pushed, will push back harder. If this goes unanswered, if defendants can disrupt proceedings without consequence, then the entire framework of federal justice begins to erode. What happened in that courtroom wasn't about one defendant. It was about every case that comes after, every judge who faces defiance, every courtroom where someone tests whether the rules actually apply. Judge Caldwell answered that question definitively. The rules apply, the authority is real. And when you forget that, you will learn the lesson in handcuffs. Subscribe if you want continued coverage of how this unfolds, because this story is far from over. The appeal is coming. The trial is coming. And I'm tracking every single development. Hit that subscribe button and the notification bell right now. Here's where things stand right now. The defendant is currently in federal custody at a detention facility pending trial. His attorneys have confirmed they will file an emergency appeal of the bail revocation within the next 24 hours. According to sources familiar with the case, the appeal will argue that bail revocation based primarily on courtroom conduct rather than new criminal behavior is excessive. Legal experts are skeptical that argument will succeed, given the documented pattern of pretrial violations that predated the courtroom confrontation. Meanwhile, Judge Caldwell has issued no public statement beyond his written order. Sources close to the court indicate he is treating the matter as routine, despite the extraordinary attention it has received. He's not giving interviews, he's not commenting, he's just proceeding with his docket. One source told legal media that's exactly how federal judges are supposed to handle this. Prosecutors have indicated they may file additional motions related to the defendant's post-arrest statements and the social media activity of his supporters. The trial date remains scheduled for 3 months from now. With the defendant now in custody rather than on pretrial release, his ability to participate in his own defense preparation changes significantly. Defense attorneys have 48 hours to request a status conference on detention conditions. Keep a close eye on the appellate filing when it drops, likely tomorrow or the following day. The arguments the defense chooses will signal their strategy for the remainder of this case. And watch the government's response. If prosecutors add new charges based on conduct after the courtroom confrontation, this case escalates further. The next 72 hours will determine whether this remains a bail dispute or becomes something much larger. The stakes couldn't be higher. The evidence couldn't be clearer. A federal judge declared in front of the world that his courtroom will not be a circus, and backed up those words with immediate action. What happens next will define how courts handle defiant defendants for years to come. The appeal, the trial, the precedent, all of it flows from this single, explosive moment. This isn't just another legal story. This is about whether the rule of law means something when tested. Judge Caldwell answered that question. The defendant is in custody. The message has been sent. Subscribe and hit the notification bell. I'll be covering every development as this case moves forward. I'll see you in the next one.